Good morning, Mr. Conroy.
Good morning. May it please the Court, my name is Kevin Conroy from the Attorney General's Office. I'm going to address the issues of the merits, the standard of fraud, and my colleague is going to address the balancing of the equities or the public interest.
Could I just ask you this question, and anybody can answer it? What's the actual status today?
I believe my brothers can address that better. I know the project has moved forward. Some construction has begun on the site. Okay. Your Honor, an important issue in this case has come down to the standard of fraud used in 149.44d and a half. The decision of the pre-qualification committee shall be final and shall not be subject to appeal except on grounds of arbitrariness, capriciousness, fraud, or collusion.
Would you say that it is arbitrary for the town to essentially discount and not consider a misrepresentation made?
Yes, Your Honor.
Have you claimed that the town's actions are arbitrary?
We did not claim that in our decision, Your Honor, but I think that is a consistent decision, or would be a possible decision for this court. It's consistent with the DCAM regulation that specifically says that in the cases of where a contractor fails to, in any material way, to follow the RFQ, they shall be deemed to be disqualified from consideration.
So you're suggesting that the pre-qualification committee has no discretion but to disqualify anyone who has made a misrepresentation in its statement of qualifications, period. No, they can't discount the statement. They can't question and put aside the statement. They can't use a scoring method to take it into account. They must disqualify.
With one exception, Your Honor, in a material way.
I understand
the specific regulation says in a material way.
It represents a project that they maybe weren't fully honest about.
Correct, Your Honor.
I mean, there may be lots of other stuff in this thing, but one project in which maybe they really didn't accurately describe it, you say it's a misrepresentation. Well, let's assume it's a misrepresentation. Maybe that would not have affected the score in any way, but you're saying that's enough, that's a disqualification.
Well, and I think the DCAM regulation, Your Honor, 810 CMR 9065, specifically refers to if a general contractor fails to follow the instructions provided in the RFQ in any material way, they shall be deemed to be disqualified from consideration for.
So what you're suggesting is after bids come in a project, the tactic is to go back and look at whether there has been any misstatement in any of the pre-qualification materials as a way to essentially attack the bid.
Well, and then, Your Honor, someone who is attacking that bid needs to meet the standards of the section I just read to you in 44D and a half. Arbitrariness, capriciousness.
So committee says we were aware of the scope of the project that was reported. Mm-hmm. We were aware of their role in the project. It was not a matter that we considered to be problematic in light of all of the other information. And you say that's fraud.
No, Your Honor, what we say is fraud.
That's still fraud.
What we would say, Your Honor, is fraud is the four-part test that we determine. And provided that there's a material false statement, and provided that the contractor knew it was false or misleading, and provided they intended to mislead, that's what we define.
I have a question about the basic meaning. I mean, I must be misunderstanding the statute, but the way I read that statute, that it means that it's not to describe the application process. The fraud isn't in the application process, but fraud in the decision-making process. That sentence only is talking about the pre-qualification committee and its process.
With all due respect, Your Honor, the decision of the pre-qualification committee shall be final, right, except on grounds of arbitrariness, capriciousness.
It's fraud. It's fraud, not the fraud of the applicant, is how I read it.
I'm not sure that's. We don't read that the same way, Your Honor.
That whole subsection H is all about the pre-qualification committee, and it makes sense because it's like when you go to arbitration. It's the decisions of these pre-qualification committees are supposed to be final, except for fraud.
Except for fraud on the part of the applicant or the awarding authority, Your Honor. I mean, this is the sole provision that allows folks to go back and relook at a situation. And in the case of a situation where an awarding authority did not catch the fraud, this is the sole provision that would allow even the awarding authority to later on come back and say, you know what, we don't want this bidder because this bidder misrepresenting something very meaningful in its application. We no longer want it. This is the sole provision, Your Honor, that would allow anybody to go back and look at the pre-qualification committee's decision. And so with all due respect, we think it applies to both the applicant as well as the decision of the awarding authority.
Now, Mr. Conroy, what we have here is an appeal from the lifting of a preliminary injunction. Right? It wasn't that the appeals court, single justice, disagreed with your interpretation. He was simply looking at a balancing of the harms. Am I correct?
That is correct, Your Honor. Much of the briefing in this case, however, turned to the focus.
I understand.
Are we
Yes.
reviewing the decision of the Superior Court judge or of the appeals court? Both.
I think you're reviewing the decision of both of those. Yes, Your Honor.
I think doesn't it make a difference as to the standard of review which we're reviewing?
I think it does, Your Honor, but I believe both of those issues are before you. And the Attorney General's interest in this matter, Your Honor, is that we have a fraud standard that we determined in 2006 through our decisions in bid cases. We've used that fraud standard in a number of decisions, and it's important to the Attorney General's office, this fraud standard. Yes, Your Honor.
Let me ask you this. The town says, well, it wasn't fraud because we understood exactly the relationship between Callahan and JTC, and so, you know, there was no detrimental reliance because we got it. My question to you is, and maybe it's answered in here, but did the score, in other words, you say Callahan itself did, I forget, 3% of the work or what something. Is that
A small
right?
percentage,
Small
yes.
percentage. So when the scoring was done, was it done on the premise that Callahan had done the whole North Andover project, or did it take into account that actually Callahan itself had done 3%?
The scoring was done, my understanding, Your Honor, is the scoring was done under the assumption that Callahan had done the whole project. However, going back, if that score had changed, assuming Callahan had not done the whole work, it would not have changed the pre-qualification of the contractor. However, Your Honor, this, in our mind, a contractor who materially falsifies an application.
But let me just ask you this. In this case, you know, you can use words materially falsified, but the fact is it's about two entities that have an awful lot in common, an awful lot of people in common, and so couldn't the pre-qualification committee say, we understand all that, we just don't think that's important?
But the problem with that, Your Honor, is that if they were consistent throughout their application, that would be true. If they had listed all of the legal matters that J.T. Callahan had been involved in, if they had listed the fact that J.T. Callahan could not have finished the North Andover project, I think your analysis would be correct. They are taking on the responsibility of J.T. Callahan. It's good, it's experience, as well as it's bad. It's lawsuits, the fact it could not complete its project.
Well, they knew it couldn't complete the project, didn't it?
They say that they knew that, but what...
You doubt that they did? Are you saying, as a fact matter,
No, Your Honor.
pre-qualification committee didn't know that?
Excuse me, Your Honor. No, I'm not doubting what is said in those affidavits.
Mr. Conroy, let me ask you this. One of the things that we look at is the conduct of the town, correct?
Correct.
And you and others have argued that the town received this notification from the Attorney General and, if I can put it bluntly, simply thumbed their nose at the Attorney General. Tell me what happens as a practical matter. And I think that was really what was underlying, I think, Justice Cordy's questions, which is that when there's a review, somebody petitions the Attorney General under its somewhat informal review process, non-binding, and the Attorney General issues this kind of statement, what are you asking us to say as to the good faith of the town if it then looks at what the Attorney General has determined and does, you know, as Justice Bartz would suggest, another look and says, we recognize that. Is that always bad faith? Often bad faith?
No, Your Honor. In other circumstances, we've seen the town come to us immediately and say, how do we rectify this situation? In other circumstances, we've seen a town challenge the decision of the Attorney General, bring that to Superior Court right away. We've also seen towns who keep the Attorney General updated on the status of the project, inform the Attorney General that the project is going to move forward, and allow us to understand the circumstance. In this case, Your Honor, we wrote a letter to the town indicating the town that they should cease from continuing work on the project. Apparently, they moved ahead with the project. Apparently, they signed a contract while the Attorney General's investigation was continuing. That is what we consider the town's bad faith in this matter.
I have a question about the underlying procedure, please. Does the Attorney General typically issue a request to defer work when a bid protest is filed?
Yes, Your Honor.
So then, in other words, that's just routine.
It is routine, Your Honor, but my experience in the briefs of some of the amicus say most awarding authorities follow our instructions in this case, or at least let us know that they are going to continue. The problem in this case, Your Honor, is that the awarding authority in this case signed a contract while our investigation was proceeding.
Thank you, Mr. Conroy.
Thank you.
Good morning. Mr. Soulis, have I...
May it please the Court, I'm Christopher Soros on behalf of the taxpayer plaintiffs in this case. And I'd like to direct my attention to the question of the propriety of the single justice's decision to vacate the injunction. And I think that...
let me ask you this. Could you have lodged your protests earlier, as the town suggests?
Well, I think it's possible if the individual plaintiffs were aware of the underlying circumstances, that they could have joined in the protest, but the fact is that there were protests pending before the Attorney General's office, and there was every reason for everybody involved to assume that the town would comply with the decision of the Attorney General's office.
Well, the protests came in after the bids were opened. A disappointed subcontractor protested, right?
That's correct.
This is months after the pre-qualification process has ended.
That's correct, Your Honor.
And I take it, maybe I'm wrong, were the statements of qualifications public when they were filed?
They're subject to public disclosure under the public records laws. Yes, you're correct.
And you can ask for. You can ask for them.
You can ask for them, yes.
But they're not published.
You have to make a public records request, is my understanding of it. But, Your Honor, I think I'd like to address what I think you're getting at, which is the delay in even the protesters filing the protest with the Attorney General's office.
The point of this, of course, is to have as final a decision as can be had with respect to who will be able to bid. Then there's so that the bidding process at the end isn't compounded with this qualifications issue.
That's correct.
And
Your
so
Honor.
that contractors know that they're qualified.
That's
and
correct.
they can invest money, because these bid preparation costs can be fairly extensive on a big project, and then can bid, right?
That's correct, Your Honor. The problem is that when you have a violation such as what occurred in this case, which is that the prospective bidder submitted an SOQ that contained a material misrepresentation of fact, the nature of the violation is such that it's not necessarily apparent on the face of the document. The violation requires, determining that a violation existed requires somebody with knowledge or somebody going and investigating the underlying circumstances. And that's my understanding of what happened.
I take it that might happen in the following way. Somebody says, Callahan got the bid, and then, Peter Callahan shows up, and, a sub says, excuse me, what are you doing here? Well, I got the bid. Well, you've got nothing to do with the Joe Callahan. That's a different company.
Right.
And then digs around and sees that,
Right.
oh, yes, they're overlapping, but they're completely different. They're not incorporated. They did not, in fact, do the work that they said that they had done. They did not have the experience as this corporate entity. They would not be responsible for any of the liabilities of the other company, et cetera, et cetera, et cetera.
Well, Your Honor, I think the Modern Continental case is very instructive on this issue, because in Modern Continental, it likewise involved a pre-qualification.
But that's a completely different statute. But that's not this. This was passed 20 years after Modern Continental.
But it's
that involves certification at DCAM.
Well, actually, if you look at footnotes 5 and 10 in the Modern Continental case, the version of Chapter 149 required awarding authority pre-qualification.
Yeah, and that was changed to certification shortly
Later,
thereafter.
yes. So the pre-qualification.
And that has nothing to do with the town pre-qualification committees.
Well,
Here.
and it's a different statute. Yes, you're right, Your Honor. But
Okay.
but what this court in Modern Continental was dealing with was a lawsuit by Modern Continental, which was not the low bidder, which filed the lawsuit after the bids were open, claiming that the procedures that it had complied with during the bidding process were unlawful. And the court in that case, this court in that case, determined that because of the severity of the violation, it involved a substantive violation of Chapter 149, that notwithstanding the fact that Modern Continental sat on its knowledge that the process that it itself was participating in was unlawful and waited until after bids were open, this court nevertheless issued or approved injunctive relief in that case because of the significance and the importance of enforcing substantive provisions of Chapter 149. And that's
Your view is, no matter what the pre-qualification committee here may have known, may have considered, the fact that there were a material misrepresentation on this means rescission is the remedy you're entitled to.
the DCAM regs make that absolutely clear, I think.
DCAM regs don't really say that, do they?
Well, they do, because they say that any prospective bidder that fails to respond to an RFQ in any material way shall be...
We're past that. The pre-qualification committee has already qualified this person. The question is setting it aside.
That's
All right?
correct, Your Honor.
Setting aside that pre-qualification decision on the basis of fraud.
Yes.
And I'm asking you in that context, are you automatically titled to rescission where the committee, let's assume for a second, the committee was aware of the misstatement, it did not affect their judgment, there's no allegation of collusion, and no allegation that the decision was arbitrary in the town proceeding as it did?
I think absolutely, Your Honor. What Callahan did was...
And that it doesn't matter what impact this may have on the town, its school system, its student body, its finances.
Those are appropriate inquiries, but I think under this court's consistent holdings in cases involving substantial violations of Chapter 149, the ordinary consequences of injunctive relief, additional expense and delay, are superseded by the paramount importance
Well, there are more
of enforcing the
consequences
law.
than just expense and delay.
Well, I don't think the record supports that in this
Okay.
case, Your Honor.
All right.
I see, well, I have...
But let me ask you, is our decision as to whether the trial judge abused his discretion or whether the single justice abused his discretion?
Well, I think under the standards that govern review, it comes down essentially to the same thing. But, of course, the trial court issued an injunction. We think it was appropriate. The single justice vacated the injunction. We think he abused his discretion by failing to apply the proper legal standard, which is recognizing this distinction between technical violations of 149 and substantive violations of 149.
But he agreed with the substantive violations. I mean, didn't he accept exactly what Judge Chin took as the sort of governing law? He just balanced differently.
He actually didn't engage in the kind of balancing that this court requires, which is, again, in the Modern Continental case is very instructive. The town in that case alleged exactly the kinds of, and with substantially more record evidence, harms to the town that Hanover is raising in this case. And notwithstanding those harms, which even went beyond, in this case, to the point of raising public health hazards because of the pollution that was going unabated, this court nevertheless, because of the substantive violation of Chapter 149, approved injunctive relief. And even at the very end of the court's opinion, said that even an awarding authority's good faith, even if the awarding authority is acting entirely in good faith, injunctive relief is mandatory in a case like this.
Thank you, Mr. Sulis.
Thank you.
Mr. Toomey?
Thank you.
May it please the court, James Toomey for the town of Hanover, and with me is Brian LeBlanc I will address the injunction issues here. Mr. Lasorda will address the question of interpretation of fraud.
You were on notice of the Attorney General's decision by October 30th, 09, if I'm correct.
That's correct, Your Honor.
Okay, so that was 1 month after the notice to proceed issued, and that wasn't so long. You went ahead anyway.
If Your Honor, please, if I could go through the timeline to
I
describe.
understand the timeline.
Okay. At the time we went into the Attorney General's office, we informed the Attorney General that the notice to proceed had been issued. We explained the difficulties we have with the schedule, which was a schedule
Is
that had
there
been...
any question factually, Mr. Toomey, that there was a material misrepresentation in the original application from Callahan?
There's no question that the town absolutely understood
Afterwards?
when it evaluated, in June, when the pre-qualification committee evaluated those documents, they understood. And that's shown by the fact that Callahan only got 2 points for prior public projects. That was taken into account. It was part of the evaluation.
What about the fact of J.T. Callahan's lawsuits and other problems that weren't part of this application?
Well,
Did you know about that?
Mr. Miller's affidavit indicates that he understood that he was dealing with a company called Callahan, that there had been a prior company named J.T. Callahan, that it was dealing with a separate company on that separate company's record, which had a very little, or a small part of the North Andover High School project. They understood the difference between the two.
So
And
your basic position, as I understand it from the town's point of view, is anybody can make any misrepresentation about their corporate status, that they're a predecessor, a successor, they're incorporated, they're not incorporated, how much work they performed, they haven't performed. All of it is false. All of it is misleading. All of it is, as both the Superior Court judge and the Appeal Court judge found, was knowingly false, intended to mislead, okay? And then the town, in its assessment, can say, oops, yes, I understand, but let's see now, 8 out of the 9 came to work, and you didn't really complete the project, and we never... I mean, what is the point of having the pre-qualification in the first place?
Well, the point of the pre-qualification is for a local pre-qualification committee. Now, remember, DCAM does its own qualification first, then the local building authority has the ability to look at that. They can assess whether something is so serious that they don't trust the contractor, apart from the substance of it.
Who can assess it? The town?
Pre-qualification committee, which is made up of the members of the building committee, their construction consultants, including an architect.
How am I to view the decision of a pre-qualification committee if it says, I don't mind that there was intentional fraud? I mean, it's not accurate what is put there. But I can check it out, I can ask the person, they can come in and they can just explain to the committee, and so I sort of just disregard that. I mean, isn't that a rather bizarre position?
Not if you're sitting in the chair and you're doing the evaluating, and you can say, with the information we've got and what we know, I mean, first of all, this pre-qualification committee did not view this as that kind of what you've described.
No, I understand that.
As a
That's
serious
my
misrepresentation.
point.
They
And
understood it.
The Attorney General did. Right? The Attorney General says this is an open process, and one of the things, don't you sign under the pains and penalties of perjury?
That is true.
Right? You sign under the pains and penalties. I mean, the whole structure is be open, be honest, be correct, be very certain that you're correct in what you put down in an application. And then a town chair of a pre-qualification committee says, oh, well, we don't pay any attention to that because we...
That isn't the process, Your Honor. The pre-qualification committee, if you look at the affidavit of Mr. Miller in the
Right,
record,
which
he
I have.
understood what that was. It wasn't a case, in his view, of a material misrepresentation. It was a case of, they said North Andover, we know what they did in North Andover. They said some of the people used to work for Callahan, we understand what that is. But if you look at their scoring, they only give 2 points. That is a local decision to be made in the evaluation by the building committee and its consultants. And
So
I
you're
say they can
saying-
evaluate
so you're
that. No, there
saying
was
in effect, that we should we should whitewash, say it's okay to misrepresent in the application process, and then putting that together with the appeals court justice's decision, saying that if you do something wrong, but you can get the process going quickly enough, then you'll succeed.
Well,
Is that what we want to say?
Let's go to something wrong here if we get going quickly enough. I want to dispel the view that this was a race to get a shovel in the ground before the process, the legal process got going. First of all, the schedule that we're dealing with here was established many months before this pre-qualification occurred. The Attorney General was informed first thing, we're on the schedule. It is a critical schedule in order to get this school open in time. We need the good fall weather to get the things done before the winter sets in.
I thought you just told me you were going to persuade me that this was not a race to get a shovel in the ground. This was a race to get a shovel in the ground.
No, it was not, Your Honor. This was following a schedule that had been established well before any of this business arose.
No, I understand. And you've got a school year, and you've got the fall, and you want to get it started.
Of course we do. But we're following a schedule. This isn't a case where we said, oh, let's advance before so we can get this done.
I understand that. But that is influencing all kinds of decisions.
Well, and those were carefully made decisions. When that Attorney General's decision came out, first of all, it was not consistent with what the town understood the facts to be. It was
in what way?
In that it talks about the town being, or about the facts being misleading and intentionally misleading. The town understood those facts. And the Attorney General just short-shrifted that. Second part of it was, when you look at the standard, what do you overturn these decisions on? It's fraud. The town isn't even deceived, so that there's no fraud. And then the last thing is your decision in an essay, which says these decisions are not even entitled to evidentiary weight. No evidentiary weight. Now, when the town looked at all of that, and should it disrupt the schedule that it had, should it jeopardize the project, it made a reasoned decision. These are bodies, municipal bodies coming together. It's not someone just running ahead. It was reasoned. It was thought out. It was a tough decision to make.
So your position essentially is that there was no fraud because the town was aware of any alleged misstatements or whatever you want to call them. The town was aware of them, and so there was no fraud.
The town was not deceived.
The
town was not deceived.
But you could posit something where the town wouldn't be deceived because the town, I'm not saying it's this case, but just hypothetically, the town and the bidder are in cahoots together, and the whole bid is ridiculous, but they're in it together, and so the other bidders are all prejudiced, but the town wasn't deceived. Now, would you say that would be okay?
That would be collusion.
That would be collusion.
And that would be a separate ground. If those facts were shown, obviously that would be overturned.
But let me ask you this. Couldn't the town's committee have disqualified Callahan for making these statements?
It could have made that decision if it chose to, and it did not. And Callahan met the minimum statutory criteria, which is 70 points. The town has leeway. And if you look at the Peabody construction case, they divide these decisions into two parts. Those that are required by the statute, those that are within local discretion. It is clear here that the minimum requirements required by the statute were met. The town made its decisions based upon the others. It scored this applicant above the statutory minimum of 7. Again, the 2 points were shown that they understood the limitations of North Andover. Very quickly, to move to this injunction issue. There seems to be some suggestion in some of these filings that the town's position is, doesn't matter what the violation was, if you're far enough along in the process so things are going to be problematic to start, then no injunction should issue. That is not our position. Our position is that the LeClaire case puts out a balancing process. And when you do the balance...
LeClaire was talking about a technical violation.
Well, I think if you want to characterize that as technical, they didn't advertise it. I would suggest...
Well, the court characterized it as technical.
Yes, and I would suggest if you compare it to what we've got here...
Well, what we've got here is we've got an open bidding process. Somebody goes in, you can look at these applications,
That's right?
Somebody wants to know whether or not... They don't happen to know who Callahan A, Callahan B are, right? And whether they look at the application on its face, it makes all kinds of representations that turn out to be false. But the person who received the next lowest bid said, oh, this is a pretty qualified contractor, right? Pretty qualified contractor. I'm not going to protest it. I mean, isn't that upending the whole reason?
No, Your Honor, that's my point. If you look at the cases that are cited on why, where a contract must be invalidated, they all go to the heart of the process. Phipps didn't advertise for the property that they're selling. You look at all of those cases that are cited, Modern Continental that we discussed earlier. In those instances, they simply did not follow a bidding process that was required. Here, the process was followed.
If I had read that application, I would have said that this new company, not yet incorporated, had spectacular success, years of experience, highly qualified, and it hadn't.
No, but the people who did, there was a section on management experience. Didn't matter whether they were with that other company or any other bunch of companies. Those were independent points that people could evaluate, Your Honor.
Well, isn't it implicit that answers or information that's provided should be truthful? And you're saying no.
No.
You're saying it doesn't have to be accurate or truthful.
I am saying
if the town knows it's not accurate.
I am saying if it's inaccurate, and that can be evaluated, and it's beyond the portion of what's required from the minimum statutory process, that the town can make an evaluation of that, and in terms both of the substance of it and in terms of the process of whether they were misled or not. And that's a decision that the town is entitled to make under Section 44D1/2, and was made in this case without anyone being deceived.
I know your red light is on, but I have a couple of quick follow-ups. You said DCAM does its own pre-qualification first. I must have missed that. What do you mean?
That's in an earlier section of 44H.
So
44B.
Callahan was pre-qualified by DCAM?
That's correct. And then there's a qualification process, which was added in 1993.
Callahan was pre-qualified by DCAM based on
Yeah.
the new Callahan's misrepresentations.
That's not in the record. I think it's a different process. I'm not really familiar with that. I am familiar with the local process.
Again, is this in your brief? I mean, I don't. I must have missed something.
It is, and I think Mr.
Okay.
Soto can address that.
I'm not going to let you go quite yet, though. There's something else mentioned, which is that the other bidders also made, now upon retrospect, misrepresentations in their SOQs. Is there a record of that?
It's very limited.
Just in that affidavit, that's
It's in the similar affidavit, Your Honor.
Yeah.
And what happened was we found out in the process of reviewing this whole thing, in the course of the Attorney General's thing, that it wasn't going to be as simple. And that was another part of this tough decision that the Building Committee had to make. It was not as simple as saying, okay, Callahan, you're out. We're going to go to the next guy, because the next guy had problems, which.
But isn't that exactly what we're trying? What the whole purpose of the statute is to get applicants to put down truthful answers in the applications, and we're not going to get it unless we get it. The whole purpose of the statute is to make people be truthful all the way along the process. And if we permit something like this to go on, we're going to defeat the purpose of the statute.
Well, I would suggest that on a broad basis that may be true. But in the given facts in this particular case.
Yeah, everybody was misrepresenting, it appears. I mean, the first bidder,
Well,
the second bidder, the
the
third
other
bidder.
cases were omissions of things that should have been there. But in this particular case, focusing on what was known about Callahan, I understand the broader concern here. But there is, in 44D1/2, this opportunity for local evaluation.
I understand. The problem that I have, and Mr. Lasorda can address it, is your fellow town councils, they don't want a narrow thing. They want a very broad discretion to determine whether, when there has been, on the basis of fraud, nobody seems to be questioning that there was fraud here. Okay?
I am.
I understand. But on the basis of fraud, town council come in and say, just leave it up to the pre-qualification committee, and we'll decide whether the fraud is good, bad, or indifferent. And that seems to me to be...
I don't think that's what the city solicitors are saying. I think the city solicitors are saying...
broad discretion to determine whether to disqualify a prospective bidder on the basis of fraud. That's what they've asked us to do.
Well,
that's pretty broad.
I think if there was fraud here, if the town was deceived, the town would go back and be able to undo its
The
decision.
difference between was there fraud here and was the town deceived, it seems to me.
You would say
It
there
seems
is
to
no
me
difference.
that's one and the same question, and the answer is the town was not deceived, therefore no fraud.
So your point is there may be misrepresentations, but the town was not deceived.
That's correct.
Thank you,
Thank
Mr.
you very much.
Toomey. Mr. Lasorda?
Paul Lasordo for the appellee Callahan.
If I could
The-
ask you, before you get warmed up,
I don't think I'm going to get warmed up.
well, how would you define the term collusion under the statute?
Collusion, to me, goes back to my brother's briefs were very heavy with ward commission issues. I think that collusion is a different standard. It is in the nature of public corruption. It is when a public official, for instance, would collude with a contractor, some untoward behind-the-scenes matter, and as long as you raise
Well, I mean, here you have, at least as alleged, or I guess at least as found by Judge Chin, an applicant who says we were responsible for a $42.5 million project building the North Andover High School. And the town says, well, we know that that really wasn't true. We knew that they only did a fraction of that. Would that be collusion?
No.
Okay.
And I will address that.
What would it have to be to become collusion? What would you need to
In
make
this
that collusion?
instance, I will address the point of the overall SOQ with the intention. I'll answer all the tough questions before. I don't think, as I said, I don't think I'm going to get warmed up. I'll be answering the questions you've raised before. But in order for it to be collusion under the statute, we could ask Mr. Hashbager who's in the audience, but I believe collusion in the statutory framework of the pre-qualification statute is talking about a undisclosed bias, personal relationship, could be bribery, could rise to that level. And that's what the Ward Commission was about.
No,
and
no,
that is
collusion-
why the cases and the preambles to many of the briefs, while interesting reading from a historical perspective, aren't on point. Like many issues in construction law, which is what I've spent 34 long years doing, it turns on specifics. You can't mix apples with oranges. There are misstatements that Justice Cordy says you can't have certain misstatements. Yes, under the DCAM statutes they cite, you can have in their briefs, but in 4.04E, 810 CMR 4.04, you can't, a material misstatement at DCAM will get you either not certified or decertified. You can't mix that up with what's going on here. And you can't mix 9.065, which is really a procedural statute. 9.065 is talking about getting your documents in on time, signing them, and all that. What the statute says, whether we like it or not, we can't read into it. The statute says fraud. What is the standard of fraud? My point is that and is it as Justice Cowan raised before, is it the fraud of the pre-qualification committee? I say that it is. There are
See, my
more.
problem, let me interrupt you,
Excuse me,
forgive me,
Justice
Mr. Lasorda. I'm looking at 44D, section 44D and a half.
Yes.
Management experience, history. I mean, part of what we're trying to do is to, I don't know whether it's just a misrepresentation. It's the core of, do you have the capacity? Do you have the capacity fairly represented? Now, if they'd come in and said, we're a brand new entity, we haven't even incorporated yet, we don't have officers, or we do have officers in here, but this is who we're going to bring onto our management team, we wouldn't have this problem.
No, that is a very, very good point. And I think it goes to the heart of this whole pre-qualification. As Justice Cordy alluded to, there are two pre-qualifications. There's the old pre-qualification with DCAM. Then they decided to separate the pre-qualification for an individual job and add another layer to it, which pulled the DCAM pre-qualification away from the town's own pre-qualification. So in June and early July, you get the town's pre-qualification. Then in September, you got the bid. Earlier than that, you had the old DCAM pre-qualification, which still exists. You have to be qualified. Now, this new Callahan company, which is very interesting, this new company was pre-qualified by DCAM
But we
for
don't,
$188 million.
but we don't have enough in the record to know on what basis, right?
Their form is similar but not exactly the same.
And were the same, quote, misrepresentations made for DCAM?
No. They pre-qualified them because DCAM believed that this Callahan company had done lots of private work. 6 out of the 7 jobs listed in Schedule E, which only took up 2 pages out of 130 pages of the SOQ, were involved with private projects. They got 2 points out of 10. They got a D- on that section. They still passed. Why? They got 20 out of 20 points in other sections. Their financials are extremely strong. And if I may, it's very critical that you compare the RFQ, which isn't complete in the appendix, and we will amend that under, I think it's Rule 17. I talked to my brother about it. We'll give you the whole RFQ. The RFQ and the statute, 44D.5, are very important to look at together because 44D.5 is divided into sections that are required. The statute says you have to have these sections that are required. And then there are sections that the town can put in. Interestingly enough, the definition of prior project experience was a definition that the town put in. That was Mr. Toomey's point, that they can, they might be in the waivable, even if there was a violation, that it might be waivable. In fact, this Schedule E, Justice Marshall, Schedule C, which is the prior project experience, is part of the overall management experience, which in fact covers Schedules A through E, I believe, and those include the very important resumes, which cover the entire first section. I believe it's after App 141, you'll find for about 200 pages, you'll find the SOQ. But you've got these resumes that clearly lay out the experience. Some of these people, like the man that's building the project for Hanover now, work for Suffolk Construction, the company that built this room. And that resume is part of what they pay attention to on management experience. That's part of why the new Callahan company came out of the chute with $188 million worth of work, yet this is their first public job. DCAM recognized the people they had with them,
I know.
et cetera. Excuse me.
The light is...
I do respect the light, Your Honor. I thought I was answering your question.
You were answering the question.
Indirectly.
And no, you did just fine, and that's what good counsel do. They may use it as an opportunity to go on, but I'm looking around a lot of people.
Okay, a lot of people. And I'm here to answer any other questions.
And I can assure you that we will look at whatever you file as long as it's with the approval of counsel.
Thank you.
After.
Thank you, Justice Marshall.
Thank you,
Justice.
Mr. Lasorda.